All right, people. Thank you all so much for tuning in to this special edition of Mikase Sukase, and I am, of course, your host, as always, Niko House. Today we're going to be doing something that we haven't done except for one other time in the past, which is we're going to be doing an analysis of the DNC fraud lawsuit because we've had the audio released to us. It's been released to the public. The only time I've done something like this was through a transcript that we had from the DNC fraud lawsuit. So it's going to be nice actually for you to hear it in real time. That's really cool. So it was weird that it released so late. I think it came out late last night. It was supposed to come out the day of, which was Tuesday. And if you're unfamiliar with the DNC fraud lawsuit, to make a long story short, and it was a very, very long story, we essentially... Bernie Sanders got cheated. I was one of the first ones to find out. Me, Jared, Liz, and a couple of the attorneys were the first ones to do something about it. And next thing you know, we are in the middle of the largest political lawsuit against the Democratic Party, well, against any party really, in the history of politics. When it's all said and done, if we can get through this, if we can somehow manage to get through even 75% of the lawsuit, and I'll explain what I mean by that. There will be two things that will be achieved. One, we will actually be able to hear testimony from any and everybody who was involved in the rigging of the 2016 primary election. Is this about Bernie Sanders winning? No. I say this every time somebody asks me that question. It is not about that. It is not about Bernie Sanders winning or losing. In fact, it would have changed nothing if he would have won. If somehow miraculously they wouldn't have cheated him at the Democratic National Convention, it wouldn't have mattered. This lawsuit would have still pursued. It would have still persisted. And the reason why, it's because our voices were silenced. Our votes were silenced. It doesn't matter if they try to reconcile it later at the Democratic National Convention after they realize it would be to their benefit, to the party's benefit, if Bernie Sanders would have won. And it absolutely would have. But it wouldn't have mattered because our voices were the ones who were silenced. Our pockets were hurt. Our volunteer hours were wasted on a campaign. Well, I wouldn't say they were wasted because we still ended up having a revolution regardless of whether or not the DNC wanted it or not, and regardless of the fact that Bernie Sanders did in fact not win, technically. But it's not how elections should be ran, and this was to send a message to not only the Democratic Party, but to any party moving forward, that if you were going to cheat, then you were going to have to pay the piper. You're going to have to face the music. And we wanted to let people know that if you keep fighting, there's more than one mechanism to get retribution. There's more than one mechanism to get accountability. We have accountability by blasting them in the media, but monetarily, we can bankrupt you. And this is what we want to show. And secondly, what this will do is give us a chance to hear everybody testify. Like I said, that's everybody. It isn't limited to Hillary Clinton and Debbie Wasserman Schultz. This is for everybody. So, Obama included, Donna Brazile, everybody you can think of, Tom Perez, Tulsi Gabbard about why she left, because of the things she saw, all that good stuff. So, I want to go ahead and get started with this audio analysis. I apologize if it's a little low. I did the best I could with the audio, but hopefully you can hear it as clearly as I can. Let's get started.
DNC Services Corporation et al. Mr. Beck, we'll start with you.
Thank you, Your Honor. Good morning. Jared Beck and Lee on behalf of the appellants. For purposes of establishing the injury necessary for Article 3 standing, the Supreme Court has held that even a monetary trifle is sufficient. In this case, the plaintiffs, who were donors to Bernie Sanders' 2016 presidential campaign, lost far more than a trifle when they paid more than $228 million in donations to his campaign, believing that he was participating in an impartial, fair, and even-handed primary process, as guaranteed by the DNC's own charter and repeated in multiple statements in the press by the DNC's employees, including defendant Wasserman Schultz.
Now, I just want to go ahead and let you all know why it's so important that he mentioned the DNC's charter, and the fact that Debbie Wasserman Schultz made statements that were counter to what the charter is supposed to force her to abide by. The most common way that a nonprofit, which the DNC and the RNC and the Green Party and the Libertarian Party are, despite them not being considered such, the most common way that a nonprofit organization is sued and loses is because they have a charter, right? They take money under false pretense and they spend it some other way. So in this particular situation, there is injury. Clearly, right? We paid money and our time, which, as the courts have showed time and time again in the past, which can be quantified as money. The DNC ignored the charter, which is part, like if the DNC at the time was running rampant, doing what they wanted to, and everybody knew about it, do you think everybody would be members of the DNC? We can answer that. No, they wouldn't. They would leave. They would have left, and they did leave when they found out that they weren't doing what they were supposed to do. When they found out that they were pretty much operating as a banana republic within the Democratic Party, people left. That is why it's so the part where Jared brings up the charter is so important, because essentially the DNC tries to allege that everybody knew that we were cheating and it's perfectly fine. No, once people found out that you were cheating, they left. They left. There's a reason that they left. So let's continue.
But there's a second path to standing in this case, in addition to the payment of money, and which has been called the classic form of Article 3 standing. And that second path is the fact that common law rights were violated, as we alleged in the complaint. In addition to claims based on fraud, negligent misrepresentation, unjust enrichment, there's a claim for breach of fiduciary duty.
Well, let's start there, Mr. Beck. Let's assume the district court got it wrong on Article 3 standing. What injury did your clients, the named representatives, suffer from an alleged breach of fiduciary duty? Because the complaint doesn't say.
That's correct. The complaint does not, with respect to the fiduciary duty claim, spell out the nature of the damages, but I believe those damages.
No, it's not damage. It's injury. Period. It's not that you say we were monetarily damaged and didn't put a dollar figure on it. It doesn't explain the nature of the injury at all. Isn't that?
So, in the original complaint that the judge is referring to, he's saying that Jared did not say that there were monetary damages. Although so from what I can remember, he said that there was a bunch of people who donated money. And I think that Jared might have left it a little loose. I don't quite recall it being that loose, because I remember reading the complaint and I thought it was sufficient. But what the judge is asking is, what is the injury? I think that we can all agree that the injury is money in time, which can be also quantified as money. And then Jared will actually go into a little bit more detail about the long-term effects of not nipping this in the bud right now.
Is that a problem for you?
Well, I think the nature of the injury is the injury that any member of an organization suffers when the caretakers of that organization, be it the trustees or the directors or whoever is responsible for managing the affairs of the organization for its members, fail in their fiduciary duty. And so
Go ahead.
We're probably going to say the same thing. That sounds a little bit circular. If anything, maybe some sort of psychic injury, which is clearly not enough.
Well, I don't think it's a psychic injury to the extent that the Democratic Party is a real organization with real members. And I think that maybe some of what is at issue in the way this case has been brought to issue thus far. But I don't think that the Democratic Party is abstract a notion, as the DNC has suggested throughout this litigation. I believe it is a real organization in which people are members. I believe that the DNC's own charter speaks of the Democratic Party as such.
So what Jared is referring to is the fact that Spiva, and he will do the same in this case or in this hearing, he said that, the Democratic Party, political parties, with these abstract things that no one can really, they're not really physical. They don't really have like, their goals are abstract, and that was the same guy who said that you could smoke cigars in the back room and choose your candidates, and we couldn't do anything about it. It was that guy. He's essentially trying to allege that the party itself isn't a real thing, that it's like an imaginary thing. It's an idea, and that it's a party of ideas, but they don't have any formal they don't have any formal structure, which is untrue because they have to file as a nonprofit. And as soon as you do that, the reason that we have people file for things like that is so that if you dodge taxes, you can be held accountable. It's so that if you commit fraud, you can be held accountable. It's so that if you commit fraud on your members, you can be held accountable. Maybe you are doing some unjust, immoral, unethical business practices, and you can be held accountable for that. You can't. The reason that the DNC and the RNC had such a stronghold today in politics is because as corporations, they actually used that leverage before the Green Party and the Libertarian Party came into fruition, and pretty much boxed everyone else into a corner and said, we're taking our ball and going to the court next door, and you can't do anything about it. That's how they did it, using their corporate stronghold, because they made it so that if you can't be taken seriously as a party unless you're incorporated. So yeah, they're a real thing, and so Jerry is correct, and that's important to remember going forward, because as you'll see, the judges doing their due diligence. I'm not insulting them at all for it, because that's what they're supposed to do. They're supposed to ask questions, but the judges will try to make this a lot more quote unquote political than it is, in my opinion. I think that trying to make it so political is the wrong angle to see this this entire ordeal from. Yeah, it's involving politics, but from a strictly legal standpoint, the DNC was operating as a business, as we heard over and over again during the election. They were worried about raising money, and for some reason, somehow, somebody thought that Hillary Clinton was the one to do so. And they were all worried about their jobs. So at a level of utility, it was a business, right? More than politics, they were worried about lobbying money going into the party, fundraising going into the party, keeping the party propped up, and it's in debt right now as a nonprofit corporation, not as some abstract idea with no structure. So let's continue.
And so from the perspective of the fiduciary duty claim, it would be our position that it is analogous to breach of fiduciary duty in any context when you're dealing with an organization, be it a corporation, and the DNC is a private corporation, although the Democratic Party, in our view, as an organization, stretches farther than that. But whenever there is an organization with members and trustees of that organization, when they fail to make good on their fiduciary duties, they cause an injury to the membership by...
What is that injury?
Well, I think it can be quantified in a number of ways. I think one is...
So Jared, just really quickly, Jared said that when you don't maintain your fiduciary duty, then it can be damaging to the members. Now, here's how I would have personally argued it. I'll let you hear how Jared argued it. He did a good job also. But here's how I would have personally argued it. If you're a member of the Democratic Party and your party's job is to make sure that the party itself is successful, why? Because you believe that that party represents your ideals, which is why you pay money, which is why you volunteer, which is why you may even work within that party. So if they claim that they're going to prop up the best candidate by all statistical standards, by all legitimate standards, by all quantifiable, quantitative, qualitative standards, and don't do that, it means that things like Donald Trump end up happening, right? It means that people lose jobs because they have nobody to work for, right? It means that those lobbyists, those organizers, those people who would have otherwise had jobs, who would have otherwise had their ideals represented in political office, in the legislature, in the executive branch, even at some point in the Supreme Court, they will no longer have those ideals represented because that nonprofit did not keep up with its fiduciary duty as a corporation. Or otherwise, once again, if we knew they weren't going to do that, I was never a member of the Democratic Party, but I'm just saying, if they knew that you weren't going to do that, they probably would have decided to go into the Green Party, for example, or the Libertarian Party for those who believe that the Republican Party who don't keep up with or don't match their ideology 100%. But they didn't give people the chance to pursue their best interests. They lied to them, making them believe that, okay, yeah, it's a little one-sided, but if it's objective, right? We've always operated objectively, and if you keep donating to us, we'll continue to operate objectively. And by the end of it, we found out that it was not objective at all. They had already made the decision, no matter how bad or unpopular that decision was. So ultimately, it hurt people within the Democratic Party. We've seen people being deported who were part of the Democratic Party. If you think if they would have had a fighting chance, at least if Bernie Sanders would have won, they would have had a clear path to citizenship. I think so. You see people fighting for marriage equality to some degree, not necessarily in the same way where they have to fight to get married. However, they do have to fight to do things like get their cakes made by businesses, and they're being turned away just because it's a gay wedding, like things like that. Do you think that if Bernie Sanders had a chance to put somebody on the Supreme Court, that would have changed? Absolutely. You see things like Medicare for all. If you think that Bernie Sanders was president, that we would have Medicare for all, highly likely. You see where I'm going with this. So the members of the Democratic Party who are counting on them to put the best, like, here, you represent us. I'm giving you my money. I may say I want Hillary, but I need you to do what's best based off of your knowledge. They had all the knowledge. They operated within, pretty much within the parameters of their self-interest and didn't do anything but call Donald Trump to win. So, in my opinion, that's how the fiduciary duty was breached. I think, and that's how it harmed the members, because ultimately it led to the members of the Democratic Party not having their interests represented in a dominant fashion within the legislature, the executive branch, and the judicial branch. But let's hear what Jared argues.
It reduces the value of the organization. The DNC has filed and is litigating a lawsuit against Russia and WikiLeaks and other parties, in which it is alleging and maintaining the allegations that due to the Russian hacking, or what they allege to be Russian hacking of their documents, donations have gone down. So when
you're bootstrapping the DNC's own financial issues to your client's injuries for breach of fiduciary duty by the DNC itself?
Well, I don't know if it's bootstrapped.
I found it weird that he was like, found that weird. I found it weird that he was kind of like, you're saying that the party not having the funds to operate at the behest of their members is harming the members? I thought it was obvious. Obviously, the judge can't really they can't really assume things, right? They're not allowed to objectively. But I just felt like it was weird the way he asked it. Like, it was such a surprise that a party not having money, losing money because of their decisions, the result wouldn't be the harming of its members' interests. I feel like that was common sense to me. But the judge is doing his job and not assuming. So, but yeah, let's continue.
Being so much as identifying an area of palpable injury
to your client as opposed to the DNC.
Well, I think to the extent that the DNC is the organization that's responsible for managing the Democratic Party, of which my clients are members, then it is identifying how that organization, at least in very hard monetary sense, and I do believe there are other senses as well. But
what are the other injuries? You said they reduced the value to the DNC. You've said that there's injury because the leaders failed to satisfy their fiduciary duties. What are the other duties flowing from any breach of fiduciary duty?
Well, I think that they are reducing the viability of the organization as a political organization in the domain of American domestic politics in the long run. And so... Also, by if the leaders of an organization that are charged with holding fair and even-handed primaries fail to do so, they fail to conduct the party as a viable source of democratic engagement, and I think over the long run they reduce their viability as a viable political party in the system.
Any other injuries besides the leaders failing to satisfy their fiduciary duty, reducing the value of the DNC, and reducing the viability of the political organization?
Well, I think reducing the value of the DNC monetarily would also encompass the Democratic Party more broadly defined.
Okay, let me ask you this question. Staying on that breach of fiduciary duty claim. What authority is there anywhere in the country for the proposition that any state's common law recognizes a fiduciary relationship between a political party and its nationwide members?
The cases that we found are limited to New York cases. And
so he's asking about precedents, essentially, that how is the DNC itself linked to the members at large around the country. And I feel like it's somewhat redundant because this is like a precedence setting case. And Jared does a very good job of explaining why it's so important that we do set this precedence now.
And New York party members.
Which is different because those were cases in which the party was deemed to have controlled the political apparatus of a certain county. They ran all the offices. They basically had a stranglehold on everything. And in a decision that has been much criticized, the Second Circuit said there's a fiduciary duty for purposes of the honest services provision of the fraud statute. But this is a far-ranging obligation that you're asking us to impose without really any precedential support. So any person that signs on as a member of the Democratic Party or the Republican Party or the Independent Party or the Libertarian Party, any party whatsoever, anywhere in the country, is owed a fiduciary duty by that party with all of its attendant obligations.
Now, I'm not gonna lie. In that scenario, I just didn't understand what was so far-reaching about that idea. You get what I'm saying, people? He's like, so you're saying that political parties should follow their charters and honor the promises that they make according to what's in writing on their charters. Because you can't, by the way, have a nonprofit corporation without a charter. You cannot have one. There's a reason for that, so that you can be held accountable. He's like, so you're saying that all parties, Libertarian Party, the Green Party, the Democrat, they should have to follow their charters and the court should be responsible for making sure that they do so? Listen, y'all, I ain't gonna lie. When he said that, I looked around. I said, is he serious? Yeah, absolutely. Why wouldn't you? This is exactly what you should be doing. 100%. Absolutely. It was just, I'm gonna rewind that a little bit just so you can hear it, because it sounded funny. Wait, like he said it in such a way that was like, hold on, is it sarcasm? Is he think that this is a reach to ask the courts to hold parties accountable, because there are real life consequences when you don't? But let's listen one more time.
Anywhere in the country for the
Handed primaries fail to do so.
being on that breach of fiduciary duty claim. What authority is there anywhere in the country for the proposition that any state's common law recognizes a fiduciary relationship between a political party and its nationwide members?
The cases that we found are limited to New York cases and New York party members.
Which is different, because those were cases in which the party was deemed to have controlled the political apparatus of a certain county. They ran all the offices. They basically had a stranglehold on everything. And in a decision that has been much criticized, the Second Circuit said there's a fiduciary duty for purposes of the honest services provision of the fraud statute. But this is a far-ranging obligation that you're asking us to impose without really any precedential support. So any person that signs on as a member of the Democratic Party or the Republican Party or the Independent Party or the Libertarian Party, any party whatsoever, anywhere in the country, is owed a fiduciary duty by that party with all of its attendant obligations.
Yeah, so that's just, it's really weird that he was like, that was like a hard ask. Like, oh my gosh, should we hold everybody accountable for their actions? Yeah, Your Honor, I think that's pretty reasonable. I don't think there's anything wrong with that, but let's continue.
Right, and a breach is actionable for damages. That's the sort of principle you want us to adopt?
Well, Your Honor, let me answer the question first on the question of New York State precedent. I think those cases do reflect an earlier time in this nation's politics, and that's why you see those cases germinate in the earlier part of the 20th century when there was an extraordinary amount of local control, I think, exerted in the nation's elections, and the local parties were the site of the action, so to speak. I think in the interim, our nation's politics have become radically transformed, and I think they've become quite nationalized, and I believe that the DNC and its counterpart, the RNC, have in this radical transformation adopted quite a position of force and influence over the entirety of the National Democratic Party, consisting of its constituent parts, that it does make sense to adopt a precedent such as that, because this is the situation to which our nation's politics has evolved.
That was eloquently put. I loved it. It was I wanted to stand up and slow clap for Jared when he said, I was like, woo, boy, you better let him know. Essentially what Jared's point is like, yeah, the only case that we have are situations with local politics, because at one point, local politicians had control of the entire party in that state or whatever. But with super PACs, with Citizens United, with the evolution of politics, the natural evolution of politics, with social media, with how macro politics has become over the last decade, yeah, it's important that we set a precedence and etch this in stone. You cannot screw over your members or other people participating in your election because, well, for one, federal law said you can't. Federal law said you can't. State law said you can't. So there's that. But also because there are long-lasting national and international consequences. The party is no longer relegated to the politics of its state or its municipality. It is affected. National politics affects state politics and vice versa. And if we don't nip it in the bud, we don't set precedents now, or if we, because right now what it's going to show is bad precedents being set now because of how far we are, because we're in the appeal process, because we made it to the oral argument of the appeal process, which is extremely hard to do. Like 6 or 7% of all cases appealed make it this far. So now, because this has been published, it is going to be published. It has been written about by the courts. The opinions are going to be published. This will set bad precedents going forward, letting the political parties know that they can do what they want to. So Jared was absolutely on point with that response. So kudos to him there.
So you want the federal and state courts of this country to solve disputes between warring factions of national political parties.
And I think that was an unfair suggestion. Solve disputes between warring factions. No, it's people suffered a monetary injury because of lies by a party with legitimate power that is incorporated as a nonprofit, and they violated their charter. I don't understand. That's in my opinion an unfair suggestion by the judge. Just in my personal opinion, some people may not think so. Some people may have thought it was objective, but I don't think so. I think it was obtuse. I think that was, he totally misheard what Jared suggested and what Jared's argument was.
So if someone thought that the DNC, instead of, as you allege, favoring Ms. Clinton in the primaries, had not done enough to favor Ms. Clinton in the primaries, given the view of some that she was going to be the eventual nominee, they could also sue the party for breach of a fiduciary duty. And if someone thought that the amount of money that the Democratic National Party devoted to the Sanders campaign or the Clinton campaign was insufficient and was ill thought out, they could sue for breach of a fiduciary duty. Right? Those are all possibilities in your mind?
Well, Your Honor,
that's the sort of regime that you would like us to adopt.
Like I said, I just think that's obtuse, and he could be being purposely extremely objective and playing the devil's advocate. But just, I don't think that's a fair question, and I don't think that because that's not what Jared said. He said, he was very clear in my opinion about what he would like to see happen, which is accountability. It's not about warring factions. Like, Bernie Sanders doesn't become elected president. You hear what I'm saying? Bernie Sanders doesn't become president if we win this case. It's not what we're asking for. It's not what the injury. We didn't say Bernie Sanders didn't become president, therefore there is an injury. We said that their actions prevented the best candidate, or really perpetuated the worst candidate and the worst results, despite their promises of objectivity. Whatever.
Well,
I'm very skeptical that is a good thing, generally speaking. I know we're not here to do good in terms of common law, but you don't have any precedent that you can cite to, either in the District of Columbia or in Florida, that goes anywhere close to what you're asking us to do. And that to me is a problem.
Well, Your Honor, I think we're at a point in the nation's political history, for better or worse, where the courts of this country have radically altered the conduct of politics in this country through Citizens United, which, you know, people may agree or disagree with it, but that's a decision which has validated a political system in which the nation's political parties exist to attract as many dollars as possible into these campaigns. And
But your case doesn't depend on the allegation that funds were derived or directed toward the Clinton campaign as opposed to the Sanders campaign.
well,
There are no allegations of that kind in your complaint, right?
I know there don't need to be allegations of that kind.
Well, I don't disagree with you. I'm just saying if you're gonna pivot over to Citizens United, this is not a case about the improper diversion of the coffers of the Democratic Party, right?
Well, I mean, we haven't gotten to discovery, quite frankly, to know the full answer to that question. But as pled, you're correct, Your Honor. It's not a case within those parameters, but what it is a case about is the payment of a substantial amount of money based on false representations and omissions that were made to people believing that they were participating in the political process as Citizens United directs us to participate in the political process by setting up this framework in which the donation of money to political campaigns is the exercise of First Amendment rights with respect to the political realm. And so my clients were doing as they've been, I would say, directed to do by the courts of this country, insofar as they're participating in a political process by opening their pockets to a political campaign, believing that political campaign was participating in a fair and impartial process.
Boom. Jared, once again, lays it down beautifully. Essentially saying that Citizens United told us, you want to affect elections, spend your money. Basically, right? Maybe you don't have the time to volunteer. Maybe you do have the time to volunteer. You don't want to spend money. But essentially, Citizens United told us that if you want to affect elections, you better spend the money, because essentially whoever spends the most will ultimately affect the outcome. So people opened up their pockets. Some people spent $1,000, $2,000, $3,000. I know people who reached a limit like every quarter, like thousands of dollars to Bernie Sanders every single quarter, people. And what happened? Now, why would they do that? If they were told you cannot affect the outcome of an election using your money, you can only volunteer your personal time because we have publicly funded elections, that would be an entirely different story, wouldn't it? Interesting. But instead, Citizens United made it so that corporations can donate, and we have to donate too. So how else are they going to participate in elections if they're not going to be held accountable for essentially violating the trust, for violating, in my opinion, what is a moral obligation that was determined by Citizens United, by a Supreme Court case? Then what's next? In my opinion, it's like a downward spiral. Okay, yeah, you can cheat. Basically, is what if we don't win this case, that is what will happen. And yeah, maybe by some miracle the parties will just die off. Maybe. I doubt that. But it will set a bad precedence going forward. It will. It really will. It really will. So, once again, great job, Jared, bringing up Citizens United and saying, like, hey, this is the way we have to donate, or this is the way we have to affect elections. If this is pretty much the most prominent way to be efficacious when it comes to elections. So, we need to make sure that it's being done fairly, if this is the only way that we can do so outside of volunteering. Unless you want to publicly fund elections, which I'm okay with. I don't see anybody jumping up for that.
You've asserted fraud claims and negligent misrepresentation claims, and I think those are where your point about the donations has more of a nexus. And I've been asking you just about the breach of fiduciary duty claim, which seems to me to sit on a whole different footing, but that's just my perspective.
I agree it does sit on a whole different footing. You're absolutely right, Your Honor. I do think that the flow of money that occurred in connection with the fraud-related claims are related to the breach of fiduciary duty claims, because I do believe that financial arrangements, including what specific financial arrangements the party had with the campaigns, something we didn't get into in the complaint because we didn't have that information at the time we drafted the complaint, but I think those issues would be potentially relevant to the breach of fiduciary duty claim.
You mentioned statements that the DNC had made or various people had made. Did you allege any statements upon which your clients relied in your complaint?
We did not allege specifically on specific reliance on any given statement by any of our clients, but we did allege for each of the fraud-related counts that our plaintiffs relied on the misrepresentations and omissions that were made by the defendants.
Isn't there a special particularity requirement for fraud?
Under 9B, there is, Your Honor.
So why do you think that your allegations are sufficient under 9B?
Because I think the nature of the fraud here goes beyond those specific statements, or even the charter obligation under Article 5, Chapter 4 of the DNC's charter. I mean, the concept that elections are run in a fair and even-handed manner in this country is something that's inculcated from birth, or not from birth, but from our earliest days in the education system. And so I think that this is as much a case about omission as it is about affirmative misrepresentation. And so I think we did satisfy the particularity requirement because we identified specific instances of affirmative statements that the DNC and its chairwoman made, which reaffirmed their general concealment of the fact that they were favoring one candidate in this primary.
I have one more question for you. I can understand the notion that those who contributed, as you call them, the DNC donor class, might have some connection to what you say are misrepresentations by the defendants. But with regards to what you call the Sanders donor class, how were they misled if they contributed directly to Senator Sanders' campaign and not to the party as a whole, so that the Sanders campaign would have conceivably used the funds as it thought, best? And how were your clients defrauded in any way, at least those in the Sanders donor class?
Okay, so Jared's going to answer this, but I want to answer it also. That was a really good question, by the way. And it's a question that a lot of people have asked me personally. And what Jared's going to explain too, but I just want to give my quick little analysis. What our idea was if the people knew that the election was rigged from the beginning, and this is just very simple, would you have donated to the Bernie Sanders campaign if you knew they were going to rig it against him? If you knew that the DNC had no obligation to abide by its charter, would you have donated to Bernie Sanders? Would you have been able to have been defrauded of your money? Would you have had monetary injury? Would you have wasted your time volunteering for a campaign that could not have possibly won? One of the things that made Bernie Sanders so revolutionary was the amount of hope people had. Like, wow, there is somebody taking on the Democratic establishment and winning. According to all the conceivable numbers, according to, I mean, if you were in the crowds, you would have saw it. There was not a time in history, not a single time in history, people, where a person brings the crowds that Bernie Sanders brought out and loses in a primary race. If you bring out more people if people are willing to put their personal time aside and spend it at your campaign rally, they're voting for you, and their friends are voting for you. Guarantee it, because that's what history has shown. To ignore that would be to ignore precedents of every political race up until this point. It would be naive. It would be not even naive. It would be stupid to believe that. So clearly, donating to Bernie Sanders, the amount of hope people had came from the idea that we believed that at least it would be 95% fair. We know that people have their political leanings, the superdelegates could have voted any way they wanted to, right? We couldn't have done anything about that, and eventually we became aware of it. But when you're limiting debates to 6 chances, when you're conniving and working behind the scenes with the media, when the Daily Beast is owned by the Clintons, things like that. When you have the Clinton Foundation involved, where people are voting as a superdelegate for Hillary Clinton while being connected to the Clinton Foundation, all those things come into play when you're deciding whether or not you want to give your money and your time to somebody, right? Maybe some people would have been more inspired to give their time, and in that case, maybe perhaps we wouldn't even have a lawsuit. People would have been so fed up with the system that maybe they're like, we're going to do whatever we can to topple this system. I'm going to volunteer my time with his campaign to help him do so. But that's not what we thought. We had hope that he could win. That's why time and money was donated. Let's hear Jared's argument.
The issue is that the DNC was responsible for running the primary process. So it was their concealment, as well as their affirmative misrepresentation of the fact that they were running the primary process in a fair and even-handed way, that was critical to the decision of people to donate to the Bernie Sanders campaign. I mean, it would be like if...
But the Sanders campaign didn't mislead them, according to you, and they donated to the Sanders campaign. So how are they defrauded in any way that's logically connected to their donation?
Well, they're defrauded by the DNC, which made the representations and omissions regarding the impartiality of the process, and that's why we've named the DNC as a defendant. And we would submit that the DNC stands to gain not just from donations that are made to it directly, but by donations that are made to any of the candidates that are...
And it was not going to favor, and that it was deliberately trying to sink.
Yes, Your Honor, those
That
donations...
doesn't make sense.
Well, I think it does make sense when you consider that of the $228 million that went to Sanders, how much of that went right into the political economic ecosystem and into the pockets of consultants and others who make their living off of campaigns. And so these people are highly connected to the DNC, and I think at the end of the day, these people, the DNC benefits from having lots of money enter into an election process from all different sides, even though in this case it, in our view, favored one candidate from the very beginning.
Okay, Mr. Beck, thank you so much.
So overall, Jared did a fantastic job, and even at the time, realizing how great he did. Now going back and listening to it again, it just is like compounds how great he really did, and how well he attacked those questions from multiple angles and brought in all different types of sides. Because we were deceived not in just one way, right? We were deceived in these rules that have been put in place, or really, I wouldn't call them rules, loopholes that have been put in place that people had no knowledge of, and if they did, it wasn't like they could do anything about it. They were used against us, and we were deceived. So let's continue.
Thank you, Your Honor.
You've saved your time for rebuttal.
Thank you very much.
Mr. Steven?
Thank you, Your Honors, and may it please the court. My name is Bruce Spiva
Hate this guy's voice.
from Perkins Coie, and I represent.
Sorry for the mispronunciation.
No problem at all, Your Honor. I represent the DNC and Congresswoman Wasserman Schultz. Your Honors, for the majority, the vast majority of Democratic voters and the candidates themselves, the 2016 primary election ended on July 12th, 2016, when Senator Sanders conceded the nomination to Secretary Clinton and endorsed her for the nomination. Secretary Clinton had received nearly 4 million more votes than Senator Sanders during the primary campaign. However, for a group of Sanders...
Lies. You cheated. You lied. We know that you got caught purging votes. You didn't only purge votes in New York. You purged them in California. Ballots were found afterwards. Ballots were found in North Carolina. But, whoo. I'm young, but he about to get my blood pressure up already. Starting off with lies. Let's continue.
Supporters, some of whom are represented in this lawsuit. The primary battle continues in the form of this lawsuit.
Once again, this is an attempt. He said that the primary battle is continued in the form of this lawsuit. And that is, once again, a purposeful, obtuse mischaracterization of what this lawsuit is about. This isn't about the primary. Like I said, if we win this lawsuit, Bernie Sanders doesn't become president. He doesn't automatically get the nominee, or the nomination, excuse me. He doesn't. But there is accountability. And there will be precedents like no other going forward saying you cannot cheat. Period. Let's continue.
That seeks to drag the federal courts into an internal party dispute and to impose a patently unconstitutional injunction.
Internal party dispute? No, it is not an internal party dispute. You have a charter. You are registered as a federal corporation, nonprofit. You have to have a charter when you do these things because you need to be held accountable for your actions in case shit like this happens. It's not an internal party dispute. I'm not part of the Democratic Party. However, my interests were hurt. I donated to Bernie Sanders. I volunteered for Bernie Sanders. I worked for Bernie Sanders. On a mission that could not have been victorious, despite the fact that you and your party said at the time that you had behaved objectively, which was a lie. It was not an internal party dispute. I'm not part of your party. Bernie Sanders was not part of your party. He can't even register as a Democrat, let's be honest. Like, Vermont will not allow him to register as a Democrat. There are plenty of people who were Green Party who gave Bernie Sanders a chance because of what he represented. Libertarians had voted for him. Mostly independents had voted for him. This is not an internal party dispute. Once again, the reason I bring that up is because the actions of the Democratic Party and the actions of the DNC specifically affected not only Democrats, it affected everyone involved, people. Let's continue.
On the Democratic Party, requiring it to select its presidential standard bearer in a certain way. More, it seeks to impose devastating monetary damages, which the plaintiffs allege in their complaint are meant to send a message to the party.
Devastating monetary damages. He is right about that. We do want to impose devastating monetary damage to the Democratic Party. He's correct. I'm not going to argue with him.
Question. Would their complaint have any more value if they had evidence that the DNC had been secretly supporting, say, Trump or Rubio? Would that make a difference?
It's certainly not this case, Your Honor. But it took me a minute to wrap my mind of Sanders supporters, some of whom are represented.
Listen to what she asks again.
The primary
Listen.
battle continues in the form of this lawsuit that seeks to drag the federal courts into an internal party dispute and to impose a patently unconstitutional injunction on the Democratic Party, requiring it to select its presidential standard bearer in a certain way. More, it seeks to impose devastating monetary damages, which the plaintiffs allege in their complaint are meant to send a message to the party.
Question. Would their complaint have any more value if they had evidence that the DNC had been secretly supporting, say, Trump or Rubio? Would that make a difference?
Ooh. Did you hear that hesitation? He is so preconditioned. He is so programmed. He didn't even know how to respond immediately. The answer is actually, yeah. No, it wouldn't make a difference for us. It would still be true. But the answer for him is, yeah, it would make a difference because they aren't Democrats. That would be the only reason it made a difference. And he knows it. See, that was one of the most brilliant questions that any of the three judges had asked the entire hearing. I was like, oh shit, that was a good question. And he didn't know how to, the answer should have been no, but he was so busy trying to think about the right way to answer him that wouldn't screw over his case that he couldn't give an answer immediately. Let's continue.
It's certainly not this case, Your Honor, but it took me a minute to wrap my mind around that. I'll admit that.
It's a hypothetical.
Yeah, that hypothetical, and so I appreciate the hard question, Your Honor, but no, I don't think it would make a difference. I think if you had a situation where the DNC were to say to donors, if you give to us money, we're going to spend it to try to elect our nominee to the presidency, and then it actually secretly funneled that money to the Trump campaign. I think that would present a very different scenario, and might actually.
Okay, so first of all, I want you all to know something. Listen to what he just said, people. Well, if they were funneling the money to the Trump campaign instead, then we might have a case. Do you know that literally what the Hillary Victory Fund was taking money from the Democratic Party and funneling it to Hillary Clinton and her campaign and her super PACs? Hillary Clinton Victory Fund. I know you all remember that. That is literally what happened. And so essentially what he is asserting is that the only difference is that Trump is a Republican and Hillary is a Democrat. Mind you, one of the arguments that he makes is how trivial this case is and is trying to decide an internal party dispute, but has no problem with the DNC raising a lawsuit against WikiLeaks, the Republican Party, and Donald Trump, which is a quote-unquote, by his standard, an external party dispute, which is really just a political dispute. That's literally what it is, and it's based on absolutely nothing, and they're being countersued for wasting everybody's time and money. His people are working against him. You have another lawsuit in another court trying to sue the Republicans and Trump for cheating, quote unquote. And you believe that the federal court apparently doesn't know how to determine what objectivity is, as he'll make that argument again in this case. You don't know how to be objective. Whose job is it to even do that? You said that the federal court shouldn't be determining political disputes, and yet the DNC raised a political dispute and asked the federal court to determine it. Yeah, sure, you have a lot of credibility.
Make out a claim for actionable fraud. But here you have something very different, Your Honor. What you have is a portion of the charter of the Democratic Party that says that the chair, then Congresswoman Wasserman Schultz, will conduct the primary campaign in an impartial and even-handed manner. And the party contends that it did just that, and that the chair will ensure that other officers and employees of the DNC will do the same thing, that they will conduct the primaries in an even-handed and impartial manner. Okay, so you have a complaint that says that they failed to do that. And we have, because we are here on a motion to dismiss, the district court granted our motion to dismiss, we have to assume that is accurate. I hasten to add, because after the argument in the district court, despite having said about 5 times that the DNC and Congresswoman Wasserman Schultz denies that allegation all over social media, part of it fomented, I have to say, by counsel, there was all this information about the DNC's lawyer admits that the DNC lied, admits.
That's a lie. That is a straight up lie. Liz, nor Jared, nor myself, nor Colin, nor anybody else, people, said that the DNC lawyer lied. I mean, he did lie in other ways, but we didn't say that he lied about what the DNC could not do. We quoted him. We used the transcripts and said the DNC lawyer said that they can choose their candidate doing whatever method and whatever means they want to. Smoking in the back room, smoking weed behind the dumpster, getting a hand job in the car. Like what you want me to do? Like, that's the truth. And his feelings are hurt. Poor baby. Pobrecito. Listen, bro. Nobody lied on you. You said it. You shouldn't have said it. But you are feeling yourself. You were getting a little bit cocky. You were getting a little bit full of yourself. And you said something you shouldn't have said. There are consequences to that.
That they ran the campaign in an unfair manner. Not true. We deny it. But we have to assume on a motion to dismiss that's the case. So what would the federal courts have to do if they granted the relief that the plaintiffs are seeking? One, they'd have to figure out who actually is what they're referring to as a registered member of the Democratic Party. Counsel?
One, we have to figure out who is a registered member of the Democratic Party. No, there's a database full of that type of stuff. Yeah. That's not really that hard to do, I don't think. Like, it's really not. It really, really isn't. But let's continue.
It was wrong. There is a definition of membership, but it's actually much narrower than what he talks about. It talks about certain representation from the states and certain elected representatives. The party is obviously trying to get as many people around the country to vote for it as possible, but that's not the definition that could be obtained.
So, Spiva just admitted in court once again, boy, that man, he be opening up his mouth and taking in both of his feces. And just, I'm not as flexible as I used to be, but you're just going to have to imagine me putting my foot in my mouth, because that's what he did. He just said, yeah, you register as a member of the Democratic Party, you donate as a member of the Democratic Party, you volunteer as a member of the Democratic Party, but you're not a member of the Democratic Party. What did you think this was? You're a slave to the Democratic Party. Hell, you're beyond a slave. You're paying them to be ignored. Congratulations. Good job, Spiva. Good job.
Applied by the court. Secondly, the court would then have to decide, what does it mean to be impartial and even-handed?
The court will have to do the impossible and decide, what does it mean to be impartial and even-handed? It's just too hard to figure out, despite the fact that the definitions are inherent in the words. But whatever, I guess. It's insult the courts by assuming that they can't make the proper judgment on what impartial and even-handed means.
These are not self-defining terms. Yeah.
No, they're literally self-defining terms. They are, by definition, self-defining. Hold up, let's look up the definition of impartiality. We're gonna look this up, cause that boy. Impartial, treating all rivals and disputants equally, fair and just. Pretty self-defining. Pretty self-defining. Okay. Even-handed, fair, and impartial. Oh shit, they self-define because impartial is actually in even-handed. Fair and impartial in treatment or judgment. We got to define what fair means, or does he not know what fair means? These aren't self-defined. They're just so abstract. These words that have only meant one thing in their entire existence are so abstract. Jesus Christ. That's not even a good argument.
If I tell you I'm going to spend money on behalf of Secretary Clinton and I go and spend it on behalf of Donald Trump, that's perhaps something that a federal court could, or a state court for that matter, could adjudicate.
Once again, he tries to bring in the duopoly. Once again, he tries to tell us if it was Donald Trump, it would be different. But if that's the only difference, then this case should be ours. Let's continue.
And determine whether or not it is true. But to determine what it means to be even-handed and impartial, that's quite another thing, and drags this court, I submit, into what I would call a church fight. And we
Ain't no church fight, bro. Ain't no church fight. Sorry. There isn't a church fight taking place in this court right now, Mr. Attorney. Ain't no church fight. You and the DNC allege that you were going to behave objectively and impartially. No church fight. We don't even go to the same church. I'm not part of the DNC. I am not. There were plenty of people who were not part of the Democratic Party. So assuming that we're all within the same church battling is a illegitimate analogy. It just isn't true. It's the metaphor doesn't work. It doesn't work in that regard. We're not part. Now, if you would have said it's like the Baptist church or the Catholic church pretty much imposing its will on everybody else, every other type of church, then yeah, that would have been a good analogy. Because that's pretty much what the Democratic Party tries to do. But this is not an internal dispute, no matter how much you try to make it one, to try to keep the federal courts out. No matter how much you try to externalize the law and keep them out of your house. This is what we have federal courts for. To solve these type of disputes. And even in an internal dispute in my house, the courts can come in and say, hey, you're not handling this correctly. Oh shit, well I guess I gotta handle it the right way.
We all know that courts cannot involve themselves into matters of theology, nor can they, under O'Brien and La Follette and any number of cases submitted in our brief, get involved in determining whether or not the party has been fair enough. No. Ain't no fair enough. It's either you were fair or you were unfair. There's a whole other word to describe that enough little addendum that you just try to add. It's fair, unfair. Fair enough isn't a thing. Fair enough is kind of like irregardless. You know, somebody says irregardless. It's like, nah, bro, it's regardless. That's it. It's regardless and regarding. There's no irregardless. There's no fair enough. And you just said that fair, by the way, being used to define impartiality and even-handed isn't enough, apparently. So I don't know why you're trying to use that. I guess he tried to use that maybe to generalize what fair could mean, but there's no such thing as fair enough. Period.
Just fine, but let me ask you a question, please.
Sure.
Didn't the district court improperly mix standing with merits?
No, Your
In
Honor.
other words, it said you don't have any injury because you can't recover because there's no claim available to you and no.
Okay, so let me say that this was probably this is the second best question the judge said, and he posed something that I don't think that I might have caught it, and I think Jared might have caught it, but I can't remember. I gotta go back and look at the video. Essentially, the judge in the last case confused injury with standing, as in He was assuming that if you can't absolutely recoup the injury, then there's no standing, or if there is, you'll get it in a second.
Nobody owes a duty to you, and you're supposed to keep the merits separate from standing, right?
And by the way, in accordance, fair, the definition of fair, because he said fair enough. They can't determine whether or not we behave fair enough. Fair only means in accordance with the rules or standards. In accordance with the rules, wouldn't you say that a charter is synonymous with rules? Or at least encompasses rules within that charter? And that the DNC is being asked to enforce the charter that contains the rules? Because that would be the definition of fair. You can't be fair enough, because even in the definition of fair enough, the only thing that would be enough of the fairness would be being in accordance with all the rules. I don't think that he understands what self-defining means, but let's continue.
And for purposes of a fraud claim, standing only, they allege that, and again, putting aside the particularity pleading requirements on the substance of the claim, they claim that they made a donation, at least some of them, made a donation based on representations.
Not accurate, Your Honor, the second part of what you just said.
No, they do say they relied. You may think that's insufficient as a matter of law under 12b-6, but they say they relied, right?
There are no particularized allegations with respect to any individual plaintiff that they even heard the statements.
They say
This is what you call poking holes. In debate, you will hear people make these nonsensical, petty arguments to try and just derail the conversation. He's saying that so Jared and Liz wrote that that the people relied on objectivity, which we did, and relied on the statements, which people did, that the DNC was going to behave impartially. He's saying, well, they didn't say a specific statement. That doesn't matter. And the judge will explain why that doesn't matter. First of all, you can't rely on something that you haven't heard or read. It's stupid. Second of all, you have to assume that it's true. And then in court, you argue the merits of that claim. However, the claim has already been made and the injuries have already been claimed to have been had. So you can't argue merits in a dismissal appeal. You get what I'm there? So we still have standing based off of the claim that we made, because you have to assume that it's true. That's standing. That's not merit. The injury had taken place. That's standing. That's not merit. What he is making an attempt to do, or what he is going to make an attempt to do, which you will hear, is try and make a merit argument about whether or not we should be able to bring this in front of the court, and ignore the entire reality that the judge is going to bring up, that this is standing no matter what the next court may decide. That is for the next court or the next jury or whatever to decide whether or not the claims are meritorious.
They allege that they relied.
There are two paragraphs in the complaint, Your Honor, in which they say generally that plaintiffs relied upon the statement. That's type of insufficient.
That's my point.
Yes, right.
They claim reliance.
That's insufficient under both 12b-1 and 12b-6, Your Honor.
Well, I'm not sure about 12b-1, but they claim that they made a donation, that they relied, right? And they allege that, at least in part, or they request at least in part, that their donations be refunded to them. How is that not injury, causation, and redressability?
I'll take them one at a time, Your Honor. And I do think that in some instances here, they don't have standing for the same reason that their claim would fail if you got to it. I don't think that...
See, he's trying to conflate merit and standing once again. He's like, oh, we don't have standing because if a judge heard this, then it would fail. You can't do that. That's not a thing. You can't do that in court.
That was improper of the district court because if you have not articulated an injury, you don't have standing. If it's an injury that can't be redressed by this court, you don't have standing. But also, if you don't...
We have money and time. Money. People spend a lot of money. I don't know what else. That is an injury. And once again, the judges do a very good job probing him on this.
Alleged damages, you can't make out a claim of negligence or...
If you allege in a fraud claim that you gave money to somebody based on a misrepresentation that you relied upon, how is that not injury for Article 3 purposes?
I have to dispute the premise, Your Honor, because there is no allegation in the complaint that any of these plaintiffs even heard these representations, much less relied.
You can't rely unless you've heard. Right?
And none of them alleged that they heard or relied.
If you just told me that they say, although you...
He just said, you can't... The guy just said that that in the complaint we said that we relied. The judge said, you can't rely unless you've heard. He said, and none of the complaints allege that they've heard or relied. He is talking himself in circles. And once the judges, in my opinion, once they go back and hear this, they're going to be like, this guy has no idea what he's talking about. He's just saying shit off the top of his head. That's what it sounds like. I didn't realize how bad it was until I just went back and listened. It was bad. It really was.
You think it's a blanket and conclusory statement?
Boilerplate, Your Honor.
Yes, that's always a defense characterization of a pleading.
I'm a plaintiff's lawyer usually, Your Honor.
It's good to switch off and on.
But I know boilerplate when I see it.
Okay.
I'm sorry, I didn't...
How can that not be injury?
It's not...
If you don't have reliance, you may not have shown causation.
No.
But how can the loss of money not be injury in fact under Article 3?
Because they
Explain that to me.
Because they've made no allegations connecting...
That's causation.
Yes, which is part of the standing analysis.
Yes, but it's not injury. And the district court said no injury.
Okay.
To at least some of the claims. And that...
Right.
We not only have to figure out how to decide this case, but how to do that.
It's their burden to properly plead standing, and a boilerplate allegation that all of the plaintiffs relied upon these statements when you have no specific allegation that they...
He literally just keeps repeating himself because he doesn't understand the question that is being presented by the judge, which I think he perfectly understands it, and he knows he doesn't have an argument to counter it. And the other judge allowed him to slide by a little bit there because that other judge had like 50,000 questions to ask. And at a certain point, I figured that it was going to get lost, like the actual arguments were going to get lost within his questions, because it just became convoluted after a while. But this judge is like, no, you're not skating past this, bro. What are you saying? Because there is clear injury here. People spent money. And your whole argument, if he would have, I don't know what, you can't really make an argument, but he's going to make one anyway. There's not really a legitimate argument to make. There is injury. This is a case, and it should be being heard in discovery. And then there we determine whether or not the arguments have merit.
Even heard them, let alone relied upon them, is insufficient under Iqbal and Twombly
Well, that's
as
causation.
a standing matter.
So that's causation, not injury.
Well, it's injury as well, because if they didn't make the donation because of something that...
No, those are separate things. You can't link those things. They're separate inquiries.
You can't.
They have departed with their own money.
Right.
That is a financial loss or detriment.
But they can't show reliance if they didn't even...
And there's no causation.
Yeah. Okay.
So the district court got injury in fact wrong on some of the claims.
Right. Well, in addition...
You heard it? He said the district court got injury in fact. That was one of the claims that he dismissed us on. But the judge just said the district court got injury in fact wrong on some of the claims, which he did. And then Spiva agreed. He said right.
Yes or no?
Sorry. No, it did not. It did not get it wrong, because in addition to the reason I was giving a minute ago, it also
Ain't change your mind now, bro.
The injury that they were articulating is way too generalized.
How can your law...
The injuries that they were articulating were way too generalized. Money is the injury. Money. Money. What's so general about that? I mean, if you want to pay it back in 5, 10s, 20s, or 100s, that's what you mean by generalized. Yeah, then we don't know how you want to pay it back. But money is the injury. Money. Money, money, money.
Loss of your own personal donation be too generalized? That doesn't make any sense to me. For some of the claims, I'm not saying all of them. Well, if you say, I gave $30, I was defrauded, right? How can that not be injury to you? You may lose on causation, you may lose on regressibility, you may lose on lack of particularity, you may lose on a whole host of other things. But how can that not be injury in fact?
Right, I would say yes, you lose on all those other things as well. But B, what I would say is, if the reason you're saying I was defrauded out of that money is because I wouldn't have given. Let's take.
You're going to the merits of the fraud claim.
No, I'm not, Your Honor.
Yes, you are.
If
You're trying to show reasonable reliance.
No, I'm trying to show generalized injury because you don't have a right to dictate how the party runs the organization and how
That's
it
merits.
applies.
That's merits.
It's also standing, Your Honor.
No, it is not.
Because it's too generalized.
You cite me a case that links those two things that way and mixes them up.
Lujan v. Wilderness, Your Honor. And let me give an example. Because one of the things they say is that
Lujan, there was no injury because there weren't sufficient allegations that the individuals there, if I remember the case correctly, would return to foreign lands to look at the animals who might have been impacted by the United States agency's monetary decision on a grant.
Well, this is just as bad because
This is past injury, not prospective, forward-looking injury.
if I might, Your Honor, they're saying that the party did not run itself properly. It didn't interpret.
No, we're saying that the party did not abide by its charter. Let's make that very clear.
Interpret and implement its own charter properly.
No, not interpret. It says even-handed and impartial. Not interpret. It did not implement it properly. It broke the law. It took money while breaking the law. Continue.
If that's the case, we deny it. If that's the case, and that is their injury, that's the source of their injury, because they're saying if they had run it properly, I wouldn't have given any money.
Yeah.
That's an injury.
Yeah.
No,
Yeah.
they said if they wouldn't have told me they were running it properly, I wouldn't have given any money.
Right.
Thank you. The judge gets it. The judge gets it. Not if we were running it properly, but you told me you were running it properly. You told us that you were going to behave impartially and even-handedly. You told us you were going to follow. Like, you told us. And you didn't. That is where we diverge, apparently, because I don't get what's so hard to understand about that. You told us. We remember those statements that you said we couldn't rely on unless we heard? We heard them. We read them over and over and over and over and over again.
But you have to determine whether or not they actually ran it properly in order to determine.
He just said we can't determine whether or not they ran it properly. We can literally look at the charter. We can look at the charter. Not to mention the past, but also the charter. The freaking charter. We can look at the charter to determine if it was ran properly. We looked at the charter, it wasn't ran properly. It wasn't ran properly. I don't know. It wasn't.
That's merits.
Yeah, but it's also standing because it's something that they share with not only every person who gave to the Democratic Party, but also.
No, that can't be right, Mr. Spiro. So you and I are going to have an issue on this one. If there's mass fraud and 20 million people are defrauded and they all have the same injury because they all donated $25 based upon a fraudulent misrepresentation that they were donating to a charity, that's generalized injury?
No, but
What's the difference?
The reason is that here, if you had a charity that said, look, you give us $25 and we're going to go feed hungry children, and the executive director then pockets the money and takes it away. That's fraud. That's injury. I would concede that.
Why is that injury? Why is that injury? What injury did the donors suffer?
Because they were told that the money was going to be.
No. What injury did they suffer?
They suffered the loss of their money.
Okay, that's the same so far as the donors here, right?
It's different, and this is why. Because if the person said, "Look, we're going to try to help children, and we're going to do it in a certain way. We're going to go out and we're going to talk to schools and we're going to meet with kids," and the donor said, "I think that's not good enough. That's actually not the best."
Nah. We didn't say that. We didn't say it wasn't good enough. We said, you said you were going to do this. You did this instead, even though your charter obligates you to do this. Stop with that enough, and that fair enough. You hear how you try to muddy the waters there? That's not what we said. That's not what the complaint alleges. That's not what we allege as a class. But he gonna keep on lying. Continue.
Way to help children. No injury. Because
that's because it's not an actionable misrepresentation. Which goes to the merits of the fraud claim, not to the Article 3 standing issue.
We've cited a number of cases in our brief that say that as a donor, you don't have the ability, it doesn't give you a right, and therefore an injury if it doesn't happen, to dictate how an organization runs itself. Particularly here, where we're talking about a political organization with First Amendment rights. It would be true of all organizations, by the way. I'm not.
If the Democratic Party had said, "Hey, if you donate during these 72 hours where we really need money, that money is going directly into the Sanders campaign, and all the money that had been raised in those 72 hours went to the Clinton campaign," would there be injury?
I think that would be closer to injury, Your Honor.
Bro. Money was taken, wasn't given the way it was supposed to be given. It was, if the people even perceive it to be that way, that's what he's trying to get across to this attorney, that he is trying to purposely ignore. But even if we perceived that the money wasn't being spent the way it was supposed to be, even if that technically that is injury, that's what the judge is trying to get him to concede to. But he's so busy trying to argue his point, he's freaking out because he thinks the judge is about to grant our appeal, that he's just talking himself in circles and making himself look like an idiot and seem like he's just purposely being obtuse instead of just conceding that point. And it might have actually went better for him if he conceded that point. But now you're just pissing the judge off when you're trying to insult his intelligence and his knowledge of the law.
Why would that be closer?
Because you're basically there's a closer tie between what has been said.
What's the loss to each person in my hypothetical?
They've lost their money that they thought they were giving essentially to the Sanders campaign, and the money was given to the Clinton campaign.
Would they have an actionable claim in my hypothetical?
I'm not sure, Your Honor. I'm not sure about that. It would depend on exactly what was said. But
I told you what was said.
But that's
every cent donated during the 72-hour period goes to the Senator Sanders campaign. Every single cent. And it turns out that all the money, every single cent, goes to the Clinton campaign.
Yeah.
Do they have a fraud claim?
I think they might. But it's very different.
Do they have injury in fact?
They might, Your Honor.
What do you mean might?
But I think that's very different from what happened.
No. We're going to stick on a hypothetical.
Mm-hmm.
And I know it's a hypothetical. I know it's not this case.
No.
How can that case not provide Article 3 standing for a fraud claim? Regardless of whether you think the fraud claim loses on the merits on a 12b6 motion. If you think that there's no standing, tell me why not.
Well, I think if someone is told, give me your money and I'm going to put it to a certain use, I'm going to give it to the Sanders campaign, and the money is literally diverted to the Clinton campaign, that is essentially you're procuring the money by fraud.
So there is standing in that case.
I think there likely would be. Yes.
Okay.
Yeah. I think that's quite different from what we have here.
I know.
Yeah.
To build on that analogy, I want to make sure you close it out. Say that there was one scenario like the one just described. There's a specific representation. We will give this money to the Sanders campaign, and people donate. you agree that there would be standing there if they donated, if the money instead went to the Clinton campaign, right?
Likely, yes.
What if on a different telethon they said, give us money and we will give it to the very best Democratic candidate? Does that make it, and then someone who supports Sanders says, well, Sanders was obviously the best Democratic candidate and you gave it to Clinton. Does that present a different kind of injury situation in your view?
I think so. I think it would be almost impossible to show injury there, because you're essentially leaving it to the discretion of the party to determine who to give the money to, and so there wouldn't be an injury, and you couldn't show reliance, and you couldn't show causation.
And that's true even though the person is out of their money in either instance?
Yes, I think that's right, Your Honor.
Injury is injury is injury is injury is injury. Loss of money is loss of money. It doesn't matter if you believe. That's what the judge is trying. It's like, you got to argue that part in court. You don't get to argue that here. You're arguing whether or not you believe there should be a lawsuit at all. That's not the same thing. You can tell he used to be a plaintiff's lawyer because he has no idea how to defend this. He's just talking himself in circles. But yeah, let's continue.
Here you also have massive causation problems, which I think I've probably already discussed enough, and redressability, which would then bring this court into questions that go to the heart of the party's First Amendment rights, and is non-justiciable under this circuit's precedent under the Wims v. Republican Executive Committee of Florida. If there are no further questions, Your Honor,
All right, thank you very much. We appreciate it.
So in my personal opinion, he pretty much got worked by the judges, that entire thing. Because that was the main thing. I think that they're like, how are you trying to say that? Like, the jurisdiction, I think, was taken care of. That's why we didn't really have an issue with that. I believe Jared had a chance to address it, if I recall. And that was taken care of. So the main thing was injury. That was like the main claim that needed to be addressed by the court. And I don't think he did a good job defending that. I don't think he did. So let's hope. Let's hope. Let's continue. We got a little bit longer, and we'll be able to get you all up out of here.
Mr. Beck, you're back on the hot seat. Or podium.
This was Jared's best. This Jared nailed it. He nailed it.
Your Honors, one issue that I don't know if it got as developed as it could be in our brief, but I think is very, very important, is the issue of Rule 12G2, which prohibits a party that makes an initial motion to dismiss from making a second motion to dismiss that asserts grounds that were available to it in its original motion.
With regard to that argument, you cited authority in your reply brief for that proposition, but there's a fair amount of contrary authority too, right?
Well, I shepherdized it last night, and it seems to me, from what I saw in the case law, is that the 11th Circuit has not ruled specifically on 12G2 in the way that the 4th Circuit and the 6th Circuit have ruled, and they're somewhat at odds. And then there's a very recent 9th Circuit case, I think it's In Re iPad or some Apple product of some sort, which truthfully I can't remember which side it took in the dispute. My point on 12G2 is that I think the statute speaks for itself in this particular instance. It states specifically that a 12B6 motion or 12B6 grounds cannot be alleged in the successive motion. They may be brought by judgment on the pleadings or on summary judgment or a trial, but I think the statute is very, very specific about not allowing the court to consider a 12B6 motion, 12B6 grounds that are brought in a successive motion to dismiss. In this case, the defendants originally dismissed for insufficient service of process. Those were the only grounds that they raised.
Didn't they also request additional time to be able to brief the merits
I believe they did.
in that motion
I believe they did, Your Honor.
without objection from the plaintiffs?
Well, there was no objection from the plaintiffs, but I don't know that not objecting to that and the fact that they never actually did file an addendum to that motion before the hearing was heard on our process issue, I don't know that gets them out of what the rule expressly requires, which is that they would have had to bring the 12b6 grounds in connection with their service of process grounds in order to bring those on a motion to dismiss.
But if they can raise them on a motion for judgment on the pleadings, as one of the circuits has explained, why shouldn't we address those issues now? If not, what's going to happen is, if some of your claims survive, goes back down, they'll file a motion for judgment on the pleadings, and the district court's going to rule, and if it rules adversely to you, we'll be back up here again.
Well, two responses to that, Your Honor. First response is that the judgment on the pleadings is going to be a procedurally different vehicle in a substantially different posture, because they'll have presumably raised affirmative defenses and answered or denied certain of the allegations. So
You can't get a motion for judgment on the pleadings on your complaint on affirmative defense.
understood, Your Honor, but it will be in a procedurally different posture, and I think that's what the intent of the rule is. Secondly, and we raised this in our briefs, but
That was just a bunch of legal hoopla. I weren't interested in that, so I didn't go into it.
just reiterate it now. We never had a chance to amend the substantive allegations prior to the court's dismissal. We amended one time as of right to dismiss if it should have conducted and never did conduct the analysis of whether amendment would be a futile dismissal of the action. So that would have made any request on our part to amend the complaint inappropriate.
All right, people. Let me see. I think there was something at the very, very end that I wanted you all to hear from Jared. So, we got 2 more minutes. Stick with me. We're almost done. Thanks for everybody who's been here this entire time. But we're almost done.
Okay, go ahead.
I'd like to ask you the same question I asked your friend at opposing counsel's table, which is this. If the Democratic Party had done a telethon and said, please donate to us during these 72 hours and we will give it to the best possible Democratic candidate. If your clients thought that Bernie Sanders was the best candidate and the DNC had contributed to Secretary Clinton's campaign, would they have injury with respect to the donations that they made during that 72 hours?
I think for purposes of the Article 3 analysis, we would have injury because we would be able to allege that we made a donation in reliance on a statement that we believe to be misleading. I don't know that would be the same for a 12b6 analysis, though.
In other words, you might have standing, but you probably fail on the merits because you couldn't show reasonable reliance on a statement that was materially false and related to an issue of fact.
Right, I think best candidate possible is analogous to sort of what's called puffery in the advertising context. I think impartial and even-handed, which is the crux of the statements at issue here and the DNC's charter obligation, are of a much different order. I know my friend on the other side suggested that maybe there is not such a difference and that we really can't understand what impartial and even-handed are, but I submit that the courts of our country rely on understanding what that means every day when they adjudicate disputes. So I don't think it would be any different for a court to understand how those very same terms apply in the conduct of an election.
Okay, Mr. Beck. thank you very-
Boom. Jared drops the mic. So there you have it, people. Jared did a fan-freaking-tastic job arguing that case. He held his own against those judges in a much better fashion than Spiva did. Spiva was literally, he was arguing back and forth with the judges about basic common law. That he, like I said, he's a prosecutor generally, or excuse me, he's a plaintiff generally. He's not on the defendant's side. So you can tell, in my opinion, because he just kept talking in circles. Whereas Jared just, in my opinion, just blew them out of the water. I think that he handled everything very well. He took a little bit of time to process, but then when he understood what they were trying to ask, he handled it very well, both on the legal side and the philosophy side. And I think he showed exactly why it was so important that going forward we need to have a clear precedence on how to treat these matters. So with that being said, make sure you register or subscribe to us on Roku. Donate to us on Patreon. You can do so by clicking on the link in the description below,